Hey, why don't we go ahead and get started this morning while people are trickling in. Um, so we have a different grand rounds today, but one that is very timely, especially considering the fact that, we have a president who tweets his thoughts unfiltered on a daily basis. On the other hand, I think if all of us tweeted our thoughts unfiltered on a daily basis, we would probably all be in court. So there are some definite hazards that we in the medical profession, need to avoid in looking at our use of social media. I'm going to ask Jeff Callan, who is the division chief for dermatology, to come up and introduce our speaker.
Okay, thanks, Eleanor. So I met Mr. Shay when, last year when he was giving a similar talk to a group called the Association of Professors of Dermatology, of which I'm the president of that organization at the current time. Dan is a Philadelphian. He did his undergrad at Vanderbilt University, went to law school at Emory, and then has returned to practice with his family in Philadelphia, and he specializes in healthcare law. So I think it's it happens that right on top of this grand round, I don't think we could have planned it better, that right on top of this grand rounds, we had Mark Zuckerberg, who's testifying in Congress. And so I think it's very topical, and it's very topical about how we handle ourselves on social media, and that's what Dan's going to talk about, the risks that are associated with that. So, Dan, welcome to Louisville.
Thank you very much, and good morning to everybody here. My name is Daniel Shay. I'm an associate at Alice Gosfield and Associates in lovely downtown Philadelphia. And we're going to be talking today about some legal issues in relation to social media. So just some introductory statistics and information for you. Social media usage is obviously on the rise. In 2005, it was estimated that about 8% of the US population was using some form of social media. That is up to 77% as of 2016. I don't have current figures on it, but it would not surprise me if that has increased even further. Now, we're talking there just about US population, not about Russian troll bots. Don't have any numbers on those, but it's become a much more important part of American life, and as a result, a much more important part of your patients' lives and likely your own lives. Social media can be helpful for physicians to communicate with patients. It can be a useful marketing tool if you're feeling entrepreneurial. Many physician practices operate their own social media websites. They may have a page on Facebook. Some of them may have Twitter accounts. Individual physicians have Twitter accounts. And they use this for self-promotion. It can also potentially improve the quality of care if you can interact more quickly with patients or disseminate important information to them. That can be helpful in improving quality of care. So just to give you an outline of what we're going to be discussing today, we're going to start with just a general overview of how social media itself functions. I'm probably going to skip through that because I'm assuming a certain level of familiarity with social media. What I will point out is that the handout that you have goes into a lot more detail on differences between things like pages versus profiles, how the different major sites work. The primary focus is on Facebook and Twitter there, although we'll touch very, very briefly on a couple of other platforms. And then we'll dive into some of the legal concerns, focusing primarily on HIPAA and confidentiality issues, HIPAA compliance, I should say, and confidentiality issues, and then also on medical malpractice concerns. Finally, we'll wrap up with some practical guidance for physicians And before I get too much further into this, I'm going to reveal my own biases. Our practice, as Jeff mentioned, does exclusively healthcare law. Our clients are, by and large, physicians. We don't tend to represent the large, we don't represent hospital systems really. We do maybe a nanosecond's worth of work for them. But most of my clients are physicians or other allied health providers. And as a result of that my views on these topics and really on any legal issues come from the physician-centric perspective. What is the physician experience of these issues, and how does the law interact with their practice specifically? So let's dive in. First, we have just a general definition of social media. This comes from Webster's.com, or Merriam-Webster.com, I should say. Forms of electronic communication such as websites for social networking and microblogging, through which users create online communities to share information, ideas, personal messages, and other content, such as videos. It's kind of a sterile definition. It doesn't really give you a lot of information about the details on how these sites function. And it's helpful to have a real understanding of those details if you are going to navigate some of the legal issues that are likely to pop up. The two most popular sites by far are Facebook and Twitter. Facebook has estimated that it has 1 billion with a B active users. That's not including people like your grandmother who may have set up a Facebook account once and never checked it again because it all just seemed like too much and too busy and noisy and she didn't want anything to do with it. All she was really hoping to see was more pictures of her grandkids. This is active users, people who are going on and using the site regularly per month. It has most of the common features. I haven't actually described the common features, but common features for social media sites tend to include the ability to post links to other websites, the ability to post pictures, commentary. You can post videos. You can link to videos. There's a difference between embedding content, which is where you can actually view the content from an external site on the social media platform itself, and a link which will redirect you to that other site, taking you off of the social media platform. Most of these platforms now tend to lean more towards embedding content and making it easier for people to do that, because that sort of keeps you within the environment of the social media website itself, and that's what they want to do, because then they can sell advertising space and sell your data to Cambridge Analytica and other people. You also have the ability on social media to connect with other people. That makes it that's what gives it the social quality to it. And you end up in sort of this 6 degrees of separation, or since I'm from Philadelphia and so is he, 6 degrees of Kevin Bacon, where you connect to someone who's connected to someone else, who's connected to someone else, and then you end up becoming friends with this whole network of people, or friends in air quotes, in the sense of I'm connected to them, but I don't actually know them that well. Facebook has numerous privacy controls available to it. They're not always that intuitive to use, but you have the ability to really limit who sees what content. You can create custom lists of friends, people that you're connected to, and post information that only they can see. So to put this in context, I have a 2-year-old daughter, and I have friends who have met her. I have family members to whom I'm connected on Facebook, and I have a special list of people who get to see pictures of my daughter. My wife and I made the decision that we weren't going to broadcast her life to the whole wide world, and that she could choose whether she wanted people to see her baby pictures later on, and I only hope that I will raise her to choose wisely on that. But so I have a custom list that I refer to as kid-friendly, and I share pictures only with those people. And I've gone through my friends list and curated that so that there are only specific people who get to see a picture of my little girl. That's different from, the professional connections that I have. That's different from just the generic friends list I have, which includes, the guy that I was in 8th grade with who friended me at one point, and I said, okay, I guess I'll see what's going on in your life, and then never checked back on his profile again. There's a whole level of connections that you can make on Facebook, but the good news is you can control who can see what. That also relates to your personal information, your demographics, your marital status, your place of work, where you went to school, at high school, undergraduate, graduate level. You can share all of that information if you choose to, but you can also lock that down and make it private. Facebook also allows you to make your own profile non-searchable so that random people won't just connect to you and say, hi, please friend me. So as I said, there are a whole range of privacy controls that you can put in place. Twitter is pretty different. It's also hugely popular. Twitter limits you, the handout says it limits you to, I think, 144 characters. Obviously, that has changed since I drafted the handout. It's now up to 280 characters. That includes, for those unaware, punctuation and spaces. So if you're someone like me who learned to double space after a period, you're just giving up real estate on Twitter. This is why I really don't use Twitter, because short form communication like that is not really my thing. You can retweet another user's tweet. And for those, again, who are unfamiliar with the terminology here, I apologize for how silly all of this sounds. I did not make these words up. This is actually what Twitter refers to its communications as. You have each communication as a tweet. So you can retweet another user's tweet on your own account. You can delete your own messages, but all that will do is delete the message from your own account, which means that if someone else has retweeted it, it lives forever. And generally, that's just a good philosophy to have with respect to social media. Remember, folks, the internet is forever. And if you don't believe me, check out the Wayback Machine, which is an actual website that has archived versions of websites going back, I'm not even sure how far, but probably back to at least the early 2000s, if not earlier. Twitter has two privacy settings available to it. It allows you to have a public account or a protected account. Public accounts are visible to literally anybody with a web browser. You don't have to be a member of Twitter. You don't have to have a Twitter account at all. If it's a public account, you can go on twitter.com, search for the account, and read that account's tweets. And all of the tweets there will be public. A protected account is one where there's sort of a gatekeeper function that Twitter allows you to maintain, where someone has to apply to access your account. You have to accept them, but then once they're in the front door, they can see everything that you post. So again, this is different from Facebook, where people can be friends with you, but they may not get to see everything that you share. You can have your special list of friends who share political views with you that you project your rants to, but you do that without having to worry about incensing your cousin who's going to get into some back and forth with you, and it'll carry over to Thanksgiving or what have you. With Twitter, forget it. Once they're in the front door, they can see everything. There are also other social media sites or sites that have social media-like functions. We have Pinterest, Instagram, LinkedIn, which is more for professional usage. Yelp even has some social media aspects to it. All of these allow you to connect to other users. They may allow you to send messages to other users, but they're generally not set up exactly like Facebook or Twitter. So I'm not going to really delve into them all that much. So let's move on to talking about confidentiality and HIPAA concerns here. In my experience, most physician practices, most physicians have a pretty good grasp of what their HIPAA requirements are when it comes to things like paper, when it comes to your conduct within the four walls of the office. Generally, this is all covered by the privacy rule rather than the security rule, which deals with all manner of electronic protected health information. There's also the breach notification rule under HIPAA, which creates a whole set of requirements when a breach occurs, which is different from just an improper disclosure. I'm not going to get into a whole long song and dance about the nuances of HIPAA here. But the bottom line is that social media, all communications on social media are unencrypted. And therefore, if you have a social media breach of PHI, it will constitute a breach because that is all unsecured PHI, and that kicks you into the breach notification rule. By contrast, if it was encrypted, say if you were communicating with a patient through a patient portal, a secured patient portal, those are likely encrypted, and therefore if there's some kind of improper disclosure, it will likely not rise to the level of a breach. And that's a good thing because that means you have far fewer headaches to deal with in your compliance efforts after that occurs. Improper disclosures, as I mentioned, implicate the privacy rule and the breach notification rule. By the way, I go into a lot more detail in terms of background information, citing sources, all of that in the handout. So for those of you who fancy yourselves amateur lawyers, feel free to go look up the regulations. I've included citations to this. My grandfather was a cardiologist, and he believed that law school was the fallback position. So, you know, if that's something you're interested in, you can check that out. Whether a breach has actually occurred in an online context and the degree to which information has spread, and therefore the nature of your compliance efforts in responding to an improper disclosure online is going to be highly fact-specific. I'm going to get into some more information on that in just a minute. I'm going to give you guys a couple of examples of improper disclosures and how they ended up playing out in a legal sense from a HIPAA analysis perspective. But generally speaking, it will depend on the kind of privacy controls that are in place. If there's a breach of an account, or not a breach, an improper disclosure on an account that is so completely locked down and only has maybe 5 friends or followers or something like that, then that's probably a lot safer than someone who has 800 friends or a public Twitter account who broadcasts PHI. You'll analyze those issues differently from a HIPAA compliance perspective. Something else that's worth mentioning is that a failure to address social media usage may be within HIPAA policies, may also be considered a violation of the security rule. One of the requirements of the HIPAA security rule is that you conduct a security risk analysis, and then based on that, you develop policies and procedures to address the risk areas that you've identified. If you haven't taken social media into account, from my perspective, your risk analysis is incomplete. And if your policies and procedures don't at least say something like, do not share PHI on social media, thank you very much, here are the penalties that will apply if you do, then again, you have rather a hole in your policies and procedures, which means that if a breach then occurs, you could find yourself on the sharp end of the Office of Civil Rights, that's the government entity that enforces HIPAA, the sharp end of one of their sticks. Not a place you want to be. So as I say, your policies and procedures need to address avoiding improper disclosures on social media. There needs to be something in there about that. Whatever the policy is, you have to really grapple with that issue. One common misconception that pops up for a lot of my clients who have at least asked about this, and tends to pop up whenever I give speeches about this. Just because a patient asks a question of you on social media does not mean you can respond substantively to them. If you're going to make a disclosure of PHI on social media, you need to have a patient's authorization. And a HIPAA authorization itself is a very specific document. It's different from the notice of privacy practices that you give them when they walk in the door and that they sign a little thing that says, yes, I read them, and no, they didn't read them, I guarantee you. I read them, but that's because I do this for a living. And I'm always kind of curious as to what the notice of privacy practices looks like for whatever doctor's office I'm going to. But most patients aren't looking at that. To disclose on social media, you need a specific authorization. And HIPAA specifies the form in which that authorization needs to be drafted. It's not, they don't have like a single form that you use, but it looks like a separate kind of document that outlines the nature of the disclosures that you're going to make, informs the patient that they can withdraw their consent for those types of disclosures at any time, may indicate whether it has an end date to it as far as an expiration date for the authorization. So it's a very specific document, and a patient needs to sign that before you're allowed to disclose PHI to them over social media. If you get that authorization, then you can respond to the patient inquiry, generally speaking. But without the authorization, just don't disclose PHI to a patient, even if they ask you for it. So if a patient pings you on Twitter, if perchance they have managed to figure out what your Twitter account is, or if for whatever reason you told them, and they say, hey, doc, do you have the results of my labs yet? Don't respond. Or you can say, just a general blanket statement of, I never respond to inquiries about protected health information online. Please contact my office or log into the patient portal, if you have one. So some disclosures on social media may be intentional. I realize that this is hard to conceive of, but let me give you an example. In your handout, there is a link to a news article coming out of Chicago where a physician who was an ER doc took a picture of an intoxicated patient and posted it on social media. I cannot make this up. Obviously, that guy is no longer working where he was when he took the picture, but these kinds of things really can happen. In a moment of pique, or he thought he was being funny, he snaps the picture of the drunk patient and sends it off to the internet, where it now lives forever, as I mentioned. Many disclosures are more likely to be unintentional, however. It's rare that you're going to have a staff member or a physician who's going to really go wild and post intentionally pictures of patients. But the unintentional disclosure is a lot more likely. And as an example, we had a client who runs a multi-specialty clinic. They had hired a young front desk person to come in and start working for them. The front desk person had been there maybe a month, month and a half, something like that, and was very much enjoying her job. And one day a patient came in. The clinic treats a mix of sort of suburban and rural patients, and they have sites in rural areas. And one of the patients brought in an apple from their own orchard and gave it to the front desk staff member. Well, she was so delighted at this that she took a picture of the apple and posted it on social media with a message saying, I love my new job. This is wonderful. We have the best patients. Look at this wonderful apple that a patient, didn't identify the patient, came in and gave me. So that all sounds fine so far, right? There's no disclosure of PHI. Nothing individually identifiable is in the information that I've given you so far. Unfortunately, the apple was resting on top of a charge sheet for the day. So she took a picture that had the apple prominently featured, but if you looked closely, you could see partial names, partial phone numbers, partial medical ID numbers, partial addresses, all for the people who were coming in that day. So we had to do a HIPAA analysis. And because this was posted on Facebook, that meant looking at how many friends did she have? What time of day did she post it? Was the picture shared with anybody else? Did someone else say, look at the wonderful job that my daughter is now in, and that goes to a wider audience? Did she link her Instagram account to it, so now it's going out on Instagram as well? What privacy controls were in place? Did she restrict it to only certain people? Before we ended up getting into that, though, we looked at the picture itself carefully, and we determined that because all of the information was partial, there wasn't enough there to individually identify any single patient. So she got really lucky in that case. But if it had just been sitting on top of Mr. Smith's file, and you can see the tab with Mr. Smith's name, or God forbid the file's open, and you can read some of the diagnoses or aspects of the medical record or something, now you've got a real problem. That's the kind of thing that you have to watch out for in terms of unintentional disclosures. And those are the reasons why training with respect to HIPAA in the social media context is going to be really important. And I'll talk more about that a little later. So moving on to some malpractice concerns. The good news is that most physicians, in spite of seeing the utility of social media in some respects, are pretty gun shy about using social media in their practices. A Quantia MD survey of physicians conducted several years ago found that only 40% of physicians were not at all interested in diagnosing or treating online at all. That's a good thing, in my opinion. Although obviously it depends on the nature of the information that you're taking in. Just a couple of quotes from that study. There is no substitute clinically for actually seeing and examining the patient. I tend to agree with that, even though I'm not a doctor myself. I am married to one. She tends to agree with this. My personal favorite, though, is this one, which just reads, lawsuits, lawsuits, lawsuits. The primary concern in the social media context is the establishment of a physician-patient relationship. If you can avoid establishing a physician-patient relationship in the first place, then you can avoid medical malpractice liability for an online interaction. You can say, I had no duty of care to this person because there was no physician-patient relationship in the first place. There is no case law at the present that I have been able to find on social media and medical malpractice. So we don't have a large body of case law about patients contacting a doctor over social media and saying something to the effect of, doc, does this look infected? The doctor says, nah, looks fine. And the patient then ends up, dying of blood poisoning or something like that. We don't have those kinds of cases. We do have other analogous cases, and I go into this in a lot more detail in the handout. There are three cases that I discuss much more in depth in the handout. In the interest of time, I'm not going to delve into them all that much. But these involve cases where an attending physician gets a phone call from a resident who is in the hospital saying, I've got this patient here, I have these concerns, what do you think? The attending gives advice, actual clinical advice. The resident applies that advice exactly as the attending gave it to them, and the patient is harmed. The attending physician's argument could be, I have no patient, physician-patient relationship with that patient. I never even saw them. But courts have found that such a relationship could be implied if the attending was ultimately responsible for the resident's actions and for the patient care there. My personal favorite, just because of the bizarre fact pattern involved in it, involves a fishing trawler located in the middle of the Bering Strait. And from legally, when you actually get down into it, it's a pretty straightforward case. But factually, it's just so wacky. And I love how weird it is. You've got this fishing trawler in the middle of the Bering Strait. One of the crew goes into diabetic shock, and the ship's purser calls a ship-to-shore medical emergency line and says, we've got this guy, he's diabetic, he's I think he's in shock, what do I do? And the ship-to-shore doctor who answered the call gave advice, and unfortunately the crew member ended up dying, and the family sues the doctor. The doctor says, I never saw that patient, I had no interaction with the patient, I only spoke with the purser, I had no duty of care to that patient. Well, obviously that's going to be pretty easy to prove, because he had a contractual obligation at least to the company, and then therefore to the company's employees and independent contractors in that case. But the important thing from all of this is that minimal contact can be sufficient for establishing a physician-patient relationship. So the fact that you don't physically see the patient in person, the fact that you don't actually directly interact with them, may not be enough to insulate you from the creation of a physician-patient relationship. and therefore the creation of a duty of care. At which point, after that, we have to look at, well, were you negligent? Did you live up to the standard of care? All the super fun stuff that you get to consider in a medical malpractice case. I should also mention, I don't actually do medical malpractice law. Most of our work is advisory in nature. So we don't do med mal defense. Our goal is to protect you before it ever gets to that point. And to generally protect you before you end up in court or in any other kind of hearing. These are just some quotes from the case law. And as I mentioned, the analyses in these cases where we have minimal contact, such as no physical contact, where it says here, physical contact with a patient is not an absolute prerequisite. All of that is just meant to illustrate that you really could conceivably extend this into the social media realm. And I would not be surprised if in the years to follow, we end up having cases about this, assuming that most of them don't just settle out anyway. So social media can also raise issues regarding confidentiality of records for discovery purposes. When you are sharing information with people who are not supposed to be seeing it and to whom you can't necessarily extend confidentiality. If you're communicating with a colleague, for example, and you're both in the same practice, and it's all about the treatment of a patient, you can argue that the confidentiality of those records has not been breached. And therefore, you can still assert doctor-patient privilege if someone tries to discover that information in a lawsuit, I should say. But if you share it online and it's visible to everybody, or you otherwise breach the confidentiality, it could be discovered. And that's during the discovery phase of a lawsuit where we're gathering all the documentation, probably in preparation for a deposition or something like that. One line here is the E in email stands for evidence. You should assume that that also applies to social media as well. If they can pull records of your email accounts, then they can pull records of your social media accounts. If they have reason to believe that you were disclosing information that might be relevant to a case online. So let's move on to some practical guidance here. The first thing that I would say is, well, first, just because it's a major issue for physician practices these days, please, if you haven't conducted one in recent years, do a security risk analysis as required by HIPAA under the security rule. If you don't know what your problems are, your compliance efforts are for naught. They are ineffective, and you are essentially flying blind because you don't really know what your risks are. You haven't bothered to go through the rigorous process of identifying them, assigning them levels of risk, and assigning a sense of how damaging would it be if this risk were actually to occur, and how likely is it to occur. So do an SRA first, security risk assessment. After you've done that, make sure that your policies and procedures with respect to social media are clear and unambiguous, and also that they specify what the penalties will be if you violate them. And then you have to actually live by them. It's not enough to have a compliance plan or a set of policies and procedures that just sits on a shelf collecting dust and that you don't consult when things go wrong. If somebody discloses information improperly, then you got to follow the procedure of how you're going to respond to that, what your risk mitigation strategy is going to be, and then also what your disciplinary approach is going to be, and follow the procedure. For those running practices or designing social media policies, consider limiting the amount of time at work that people are allowed to use social media. You can also, you could try to impose a total ban, but let's be realistic here. Everybody has a social media device in their pocket nowadays, such as their cell phone, and unless your office or the hospital is a complete cell phone dead zone, which strikes me as a really bad idea, you're not going to be able to stop someone from just going to the bathroom and firing off a tweet in 2 seconds while they're in there, or going off on lunch break and going off campus and checking social media while they're over at the Starbucks sitting on the Wi-Fi there. So a total ban is probably going to be pretty impractical. You also have to keep in mind the National Labor Relations Board restrictions. This applies to employers who are sufficiently large that they have to comply with the National Labor Relations Act. And very, very briefly, I'm not going to go a lot in depth into this, but the NLRB has set out guidelines with respect to social media usage that stem from the requirements of the National Labor Relations Act, which permits workers to engage in certain activity that's basically meant to be protest activity, and allows them to, in sort of the brick and mortar context, if you want to think of it that way, it would allow someone to picket out in front of their employer and demand better wages, for example, without fear of employer retaliation. That has been extended into the online context so that you can't, or it's much harder to enforce social media policies that say things like you are not allowed to disparage your employer in any way ever online. The National Labor Relations Board has struck down a number of policies that were worded too broadly, such that they would impinge upon an employee's ability to engage in the kind of activity that the National Labor Relations Act takes into account. So when you're designing those policies, keep that in mind and try and work around them. That is different, by the way, from having a policy that says no disclosures of PHI online ever, and if you do it, we shoot you at sunrise. That's perfectly fine. Well, not the shooting part, but it's perfectly fine to fire somebody over disclosures of social media, PHI on social media. That kind of content control you can engage in, but sort of the disparagement stuff is trickier, and you'll probably want to consult with employment counsel if you're thinking of going down that road. If your practice or your entity is going to be maintaining a social media presence, you want to control who gets to be the voice of the business, who gets to post on behalf of the business. And that should be someone who is specifically designated, or if it's more than one person, a team of people who have been specifically designated, who are allowed to speak online in a representative capacity, or even just access the group's social media account and post from it. That will help control the message that you put forth. It will also help to prevent people from saying things that don't comport with what your organization would like to put forward as its image. Something else to bear in mind is that generational differences are likely to come into play. In my experience, people of my parents' generation, which is baby boomers and older, are pretty leery of social media. They do not like the notion of, why would I share all my private stuff online? I don't know these people. I don't want them to know anything about me. I'm not going on there. That's not true for basically Gen X and younger. And particularly for people who are millennials and younger, they've grown up in a world where social media has basically always existed in one form or another. Certainly the internet has always existed for them in any capacity where they would have been young enough to actually physically use the service. So to them, it's part of everyday life. That can play into both the attitudes of staff members and clinicians, and also into the attitudes of patients. People may not be thinking as clearly about what is appropriate to post online because they've lived their lives up until the point where they were in a position of real responsibility for other people's information. They have lived their lives feeling generally pretty comfortable about broadcasting a whole range of information that older generations might not. They may not bother with as much by way of privacy controls. Now, that may all be changing in the wake of the Cambridge Analytica release, when people are recognizing that, hey, wait a minute, the information that I'm posting out there is A, far more than just what I am thinking I am consciously posting, and B, is being tracked by all kinds of people and accessible to all kinds of people that I never necessarily intended it to go to. It's not just my friends list or friends of friends. It could be any number of people. getting access to that information. With patients, one of the risks that you may run into, and I honestly am not sure how common this is, but it wouldn't surprise me if you have some patients who might have a sense of feeling shut out of their doctor's lives if they are used to friending everybody that they meet on social media. I would like to think that most patients still have the instinct of, when you go into the doctor's office, you don't say, "Oh, can I friend you on Facebook?" But it could come up. And if you say, "I'm sorry, I don't do that," that could create some kind of a barrier between you and the patient, potentially. And that's going to need to be navigated in the years to come. Now, the AMA, there's guidance from professional associations about what kind of social media presence you as a physician should have. The AMA at one point, I think they've relaxed their stance on this, but earlier they used to say, you should have two separate accounts, your professional account and your personal account. Now, I don't think that's necessarily a bad idea. I think it makes more sense if you are going to be engaging in some kind of promotional activities for yourself to try and either raise awareness on clinical issues or to boost your own profile in terms of marketability. But maintaining a personal and a professional account is not a bad thing, but it is a lot of balls to juggle if you're going to be actively using both. The American Academy of Family Physicians has suggested not accepting patient friend requests and directing patients to look at the business's social media accounts if that's what they want to do. I don't think that's a bad idea either. And you can just say, well, as a policy, nobody in the office is allowed to friend other people on, friend any of the patients on social media, and that's from the front desk all the way up to the clinicians who run the place. The American College of Physicians advises using the same standards online that you would use in person. Would you engage socially with these people? Would you have them over for a barbecue or go out to dinner with them? Would you grab a drink with a patient? If the answer is no, don't friend them. They don't need to be connected with you. They're not actually your friend. If it's someone who's already a friend, it's fine to continue that friendship with them if they then, seek medical advice from you. But be aware of the privacy settings on your social media accounts as well. Remember the levels of customization that you can take in locking down what information is available. So, more practical guidance on HIPAA and confidentiality. I think it is really, really useful to understand how information can flow on these networks and how quickly it can be disseminated. If you are going to be running a training for people, it's probably not a bad idea to do some exercises with PHI let me back up, not with real PHI. Make up PHI just for sake of illustration. And then you can demonstrate, you could play find the PHI in photographs. What would constitute the PHI in this case? And it could be the example that I gave of the apple sitting on top of the sheet. It could be the intentional picture of the patient slumped over in the chair with, vomit down half of their shirt. Or it could be the selfie that somebody took in the office that happens to catch a patient's face in the background. That's PHI. That information is individually identifiable information about a patient. It's their face. If someone knows who that is, they can say, well, that's Joe. I know exactly who that is, just by looking at that picture. So that's one way to do it. Think about how do we get used to PHI in context, in the social media context. The other thing that you can do is, once you've done that, take the fake photo or the fake tweet or what have you, and then demonstrate how it can be shared from one person to another person to another person to another person with no ability to contain that information. In many ways, it's actually similar to email in the sense that if you send an email, like let's say you send a joke to a friend of yours and they think it's really funny and they forward that email that you sent to somebody else, and that person forwards it to 20 other people because they thought it was really funny. That person forwards it to 20 other people because they think it was really funny. You can delete the original email, but the rest of it survives. And that's the case with social media as well. It can spread really, really quickly, depending on the nature of the information. If you've got, for example, let's say a celebrity comes through your clinic for whatever reason, and someone says, "Oh my God, I can't believe so-and-so was in here," and posts it online, or posts some image of that person. HIPAA disclosure, right there. Improper, probably a breach, depending on how far it spreads, and what steps you can take to mitigate the disclosure. As I say, educate employees and clinicians alike in the use of social media in context and HIPAA information within that context. I would recommend using more secure forms of communication, or suggesting telephone or in-person meetings rather than communicating online with patients or disseminating information online. And that also includes communicating with colleagues over something like Facebook or Twitter, even if it is for what might otherwise be legitimate purposes. You know, HIPAA lets you disclose to other practitioners for reasons relating to treatment, payment, or operations. That's the line in the regulations. So if you're talking to another person in your same practice about, I'm not sure, you know, what the regimen should be in this case based on the patient's symptoms, do you think this is a good idea, what I'm coming up with? And you're doing that in some kind of, you know, private message context on Facebook, be wary of that. Obviously, someone's keeping a record of that information somewhere. So that is not a secure site to do that on. Instead, do it over a secure texting app if you have that. I highly recommend looking into that. That area is being developed more and more now, and it's definitely worth looking into. Secure patient portals are another good avenue to take. Or, you know, it's tough to beat the telephone or an in-person conversation. You can't hack what is just said between two people unless someone else is recording it somewhere else. Again, update your security risk assessment. That is essential these days. Malpractice. How do you mitigate your risks in a malpractice sense? Well, the simplest approach is don't engage in clinical activity over electronic media. Your policies and procedures should address how to respond to inquiries from patients like, does this look infected? Do you have my lab results yet? How are things looking? By the way, I'm feeling these symptoms. Do you think it's X, Y, or Z? You can simply advise setting up an in-person meeting or contacting you through the patient portal or a phone call. For more serious inquiries, like, am I having a heart attack? Advise contacting the practice, or just say, why are you talking to me? Call the emergency room, go to the emergency room, dial 911 if you're really that worried about a heart attack. Don't advise whether it is or is not a heart attack. You would think I wouldn't have to mention that. You would be wrong. If you look in your handout, there is a tweet that had this very exchange, and it still exists. You can look it up. A physician, now someone didn't actually ask the guy, am I having a heart attack? But they said, what do these symptoms suggest? And the physician said, if X, Y, and Z are present, probably not a heart attack. If someone's asking me, if I'm a doctor and someone's asking me about, you know, anything that is potentially life-threatening, the most I might do is direct them to a CDC website or a WebMD article on a given subject if they want to look into it. But then I would also say, if you are concerned about something life-threatening, go to the emergency room. Don't chance it by, you know, asking some guy on Twitter what he thinks, or some doctor on Twitter, I should say. The doctor's company, which is an insurance-related company, suggests that social media is not appropriate for doctor-patient communication, and also reminds everybody that it is available for discovery. So if you respond to the patient, it's right out there. It can be discovered by plaintiff's counsel when they sue you for malpractice, and it'll be really easy for them to do it. They may only need to copy the message from their patient's account without getting anything from you. With individuals who are not patients, again, the goal is to prevent establishing a physician-patient relationship. So, again, Don't respond to clinical inquiries if this person isn't a patient. You can say it's our policy to never respond to people who are not patients in any clinical sense online. If you would like to set up a meeting at the office or set up an appointment, please call our office during business hours. Here's the office's number. Or direct them to the website or what have you. With an existing patient, the goal is going to be to avoid harming the patient because you already have a duty of care to them. You have a physician-patient relationship with them. So when you are engaging in some kind of clinical discussion with them, within reason, low risk information that you can share with them is just general information on symptoms, a JAMA article, a WebMD page, the CDC page, without making an actual diagnosis just based on the online interaction. And of course, there's a level on which some of this is like when you're taking call and the patient calls you up and says, I'm worried about these following things. Do you think this is something that's really a concern? First, I wouldn't do any of that over social media because, again, it lives forever. It's discoverable. It's not secured. All the reasons that I've mentioned so far. But you have to ultimately use your judgment here as far as what kind of information you give them and what kind of advice you give the patient. You can tell them, look, if you're really concerned about this, go to the hospital, or we can try and get you on our schedule tomorrow morning. I have an opening at 10:30, something like that. If it's anything more serious, though, I would definitely take it offline. If you're having those kinds of discussions where you're saying, you know, this is going to be easier for me to communicate with you if we can do it over the phone. Do it that way. Do it over the patient portal. Don't do it on social media. So to wrap things up here, and then we'll open it up for questions. Electronic communication is now a fact of life. It's part of our daily lives outside of our professional lives. It has infiltrated our professional lives. Probably all of us communicate over email. Most of us have social media accounts. We may engage in some limited professional capacity in a social media context. It's going to be something that you're going to have to navigate. Social media can be really useful for engaging in marketing. It can be a great platform to disseminate general information. You know, you can raise awareness about clinical issues, like there was a mumps outbreak in Delaware recently that was making its way around a community. For people who have social media accounts and are checking that, you can share that and say, there's been a mumps outbreak. Please be careful. If you're concerned about it, here are the symptoms, link to the CDC page or WebMD or what have you. That can be social media can be a very useful tool for getting that information out. But there are risks that come with maintaining a social media profile. Younger patients, as they enter the market, are going to be even more involved in this, and God only knows what the next platform is going to be, you know, as technology advances, and the legal implications that will come into play as a result of that. But hopefully we can base our responses to it on established policies that you will have in place to respond to the current generation of social media. Physicians need to understand their legal risks in navigating these issues. And to assist with that to some degree, the slide deck here includes 2 articles that I've written on social media. They're written for a legally minded audience, but it deals with enough facts that you don't necessarily have to be a lawyer to understand all of it. They can be helpful. I've published other articles on social media in various trade journals as well, so you can look up that information. And I hope you guys have found this informative. I'd like to thank you for giving me the opportunity to speak to you. And if you have found this helpful, I speak on this subject and a range of other legal issues, so feel free to tell your friends, share it on social media if you like. And with that, we can open it up for questions. Thank you.
Thank you. That was fabulous. So I'll start things off with, I'm glad there are a whole bunch of residents here with something that I run into all the time. So I'm calling Do you
Mm-hmm.
think it's okay if I use normal saline or should I use lactate? And I, you know, I have a really hard, I mean, I feel because I'm a teacher,
Sure.
I feel some obligation to help them out, but also understand that there are some by giving advice. So I generally recommend that they go ahead and
Mm-hmm.
comment on it.
I think that's a good idea. I think if you have rules and procedures in place to address those types of scenarios, I think it is useful to stick with those. Um, One thing that you might want to ask is, why don't you want to put this in for a formal consult? What's the concern about that? But there's a reason why these rules exist, and it's often to mitigate legal liability and to make sure that proper procedure has been followed, and that way, if anything goes wrong, you can document what the steps were that were taken, what kind of information was actually shared, instead of just relying on memory or winging it or something along those lines. So if you have that option available, that's not a bad idea.
Okay, so I'll give credit. Or at a time, I don't really want to, it's, I don't want to make, don't think that it's important enough. Trying to save my time.
Well, okay, so there's an inherent tension that you mentioned in terms of you educating them and getting them in a position where they feel comfortable enough to make those calls themselves, which is kind of the point of residency. Um, but if they thought it wasn't a big enough deal to consult you, then maybe they have to ultimately make that call themselves. And if they thought it was a big enough deal to pick up the phone and call you, then maybe you should do an actual formal consult. So there's a level on which the resident is going to have to make their own judgment in that sense of, if I am calling the doctor and the attending and asking for um, their guidance and advice because I am not sure myself of the proper steps to take, then maybe we ought to do this formally. Because I've already called them and awakened them at some odd hour. Um, so I might as well do this formally. But if it's not that big of a deal, then maybe you end up having to be the one to make that call. And that'll depend on where you are in your residency. I went through residency vicariously with my wife, so I'm familiar with some of these issues. And it's difficult as you're going through this process of figuring out, when am I comfortable making the call myself, and when do I bring the heavy artillery in? That's just part of training. Yes. Hmm. That I don't know, because I don't really practice in medical malpractice. I would not be surprised if there is case law out there, and that again will be state specific. But it wouldn't surprise me if that very issue has come up. Um, I don't know what the bylaws say about that. I'm sure there are interdepartmental politics all the time, and EDs, like your story, not the first time I've heard it. But it's the kind of thing that it's going to be dependent on the laws in the jurisdiction, and I really don't know enough about medical malpractice to speak confidently on that subject. Hmm. Yeah. If you're telling them how to treat the patient, I mean, you're telling them how to treat the patient. So that's you stepping in and assuming that role. Again, this is another reason why if there are formal procedures that you're supposed to be following to do that, stick to those procedures. They exist for a reason. A lot of that is going to be to manage potential malpractice risk. Don't do it over social media. Okay, so that's an interesting question. For those who couldn't hear, and I gather we're streaming this, so I'm going to start repeating the questions back just so that the folks not in the room can hear it. The question was, is there a flip side to some of the improper disclosure stuff, where if a patient takes a photo of the physician and posts it on social media, does that violate any laws? Are there regulations that have been violated? What I will say is, unless there is some other patient's information in the room, which is unlikely because you'll probably only have that patient's chart, there's no risk of a HIPAA disclosure. So you're stepping outside the context of HIPAA and into a realm of law that's generally regarded as rights to privacy and in some jurisdictions, rights of publicity. Whether you have any ability to demand that in a context within which you could reasonably expect some degree of privacy, someone can just take a picture of you and say, post it online, and write some comment about it. I'm also going to mention, I did not get into some of the discussions that I had about the reputation websites like Yelp, and to a lesser extent, Health Grades, and really any place, or Google pages where they let you post opinions of your doctor. That has become an issue as well, and there's some social media overlap with that. I can speak to those issues, but if, for example, a patient posted on Yelp, I went to see Dr. So-and-so, they were rude and discourteous, here's a picture of them with a nasty look on their face. You might have the ability to get that pulled down. You probably won't have the ability to stop them from posting a negative review. There are generally, not every jurisdiction has these, but a number of states have what are known as anti-SLAPP laws, and that's SLAPP, which stands for Strategic Lawsuit Against Public Participation. Basically, that's a situation where a large company has like a negative review and they file a lawsuit that's a completely bogus lawsuit. It would get dismissed in 5 seconds once you get to a point where you can file for a motion to dismiss. But they know that by filing this lawsuit, they're going to make the other person take down the negative comment, because it's just too expensive to even hire a lawyer and go through all of the process. And so those are called, strategic lawsuits against public participation. Anti-SLAPP laws make it so that you can file that lawsuit if you want, but if you lose, you're going to end up paying the person that you're trying to sue's legal bills in addition to your own. And there could be penalties. I think in some cases it could apply, but definitely you'll end up paying the legal bills for them. So again, you probably can't get negative reviews taken down, and there are issues relating to how you respond to negative reviews. You might be able to get a picture taken down. It might violate a site's terms of service, for example, and you do have some rights of privacy that you can assert. Not someone who does HIPAA law. Mm-hmm. I think that that's a good approach to take. If someone's saying, look, I'm feeling chest pain right now, stop typing to me and get thee to the hospital. if you're really worried about that, or at least take an aspirin before you do that, and please, call a cab, don't drive, or an Uber or whatever. But yeah, I think if it's something that's serious, I would take it offline, or at the very least, tell them to give you a call. But generally speaking, I would not engage in this kind of activity over social media. And if you're doing it over email, okay, if it's the patient portal, that's okay. Right. Yeah, no, I would not. If it's the kind of thing where you guys don't have a policy of replying to emails within X number of hours, portal inquiries within X number of hours, then I would say and this should probably be explained to patients when they sign up for the portal. Chances are it is, and they just didn't read it, but make it clear to them that the portal is not for emergency communications. Call the office, get the on-call doc, and if it's anything more severe than that, go to the emergency room. Don't mess around.
All of our have full
Oh,
in the event.
well, thank you. This is great.
Congratulations and thanks again.
Thank you very much. This is great. Sounds good. With this. Good. I'm glad you found it useful.
So one of our residents, VA, almost came down. I mean, didn't have a patient space, just a patient.
I have gotten that question, that fact pattern, asked about multiple times when I spoke at the APP.